Welcome to Education in Focus. I'm Eliana Kernodle. Today we're discussing the U.S. Supreme Court decision that sided with parents who want to opt their children out of reading certain books in schools. Joining me to dig into this is the Center Square's Esther Wickham. Esther, can you give us the background on this case? Who was involved and what was at issue?
Yeah, thanks, Eliana, for having me. So the Supreme Court on Friday decided in a 6-3 decision to allow religious parents to opt out their children from school curriculum that had LGBTQ storybooks. In this case, Muhammad v. Taylor, the courts, after a long period of going back and forth, recognized that these parents actually do have the constitutional right to opt their children out for religious reasons, because this content from the storybooks did push LGBTQ ideology. And so this happened a couple years ago where the Montgomery County School District in Maryland actually reversed the right for these parents to opt their children out of sitting in on these LGBTQ storybooks because they said it was too difficult to manage, taking out the children that were excused. And because it is a very diverse county, one of the district associate superintendents, Nikki Hazel, explained that, the books that were currently in the ELA curriculum didn't represent many students and families in the Montgomery County District that were of LGBTQ families. And so they wanted to add books that represented these families to feel included. But again, this became an issue for people on the other side who were religious that didn't really want, their 3 to 11-year-olds discussing that without their parents there, within the school district. They wanted that right to, have these sensitive discussions and topics on their own time with their children, A, and B, they weren't even given that option to choose whether or not they want their children to be sitting in on these storybooks at that time.
So can you get a little bit more into the ruling? You mentioned it was a 6-3 decision in favor of the parents, but can you break down a little bit more the reasoning behind it?
Yeah, totally. So Justice Samuel Alito, he wrote the court's majority opinion, and essentially in his opening statements, he said that, referencing, previous court cases that had cited, for religious freedom, that they, have long recognized that parents do have the direct right for religious upbringing for their own children. They have the right to choose whether or not they want to have those discussions with their kids at a certain time, or even, bring up those conversations at all. And they, stated that, they also uphold those rights, and they recognize that these kinds of government policies substantially interfere with this kind of religious development of children. And so that was a big part that they kind of rode through, even through the concurring opinion, saying yes, parents do have the constitutional right to train and teach and instruct their children, and it is not up to the county school districts to extend or reverse that right to parents, because originally the county school district gave, and had those policies enacted for parents to opt their children out. But as soon as they take that right away, the Supreme Court recognizes that is not okay. Later on in the concurring opinion with Justice Brett Kavanaugh, he clarified that these kinds of LGBTQ inclusive curriculum with an additional no opt-out policy is actually, hurting these children as a whole. And he said, in his concurring opinion, quote, "Such an unprecedented curriculum cannot overbalance the parents' legitimate claims to free speech, free exercise of religion." So this really came down to, the county school district is invoking a really big, First Amendment rights issue.
So then what did the dissenting judges have to say? There were 3 of those. Who wrote that decision and what were the points they made?
Yeah, so the dissenting opinion was written by Justice Sonia Sotomayor and Elena Kagan and Justice Kagan and Justice Jackson sided, with their dissenting opinion. And essentially they were saying that this is, really detrimental for these religious students because they are being isolated and removed from quote unquote diverse societies. So their whole argument was saying that, this is a threat to public education, taking that free exercise for these, school districts to teach these kinds of children about diverse and different kinds of families and even, lifestyles and taking them out from that context is isolating them and ultimately, hurting them. At the end, she says the reverberations of the court's error will be felt, I fear, for generations, unable to condone that grave misjudgment. I dissent. And, she talks about the decision guts the free exercise precedent and strikes at the core premise of public schools, which, as she states, the children are to come together to learn teachings of things, all over faith, a range of concepts and views that reflect an entire generation. So in a sense, they're saying that this opt-out policy kind of narrows that context for a lot of students, which again, there's arguments on both sides to combat that, but that was one of the main issues that were brought up in the dissenting opinion.
Well, Esther, thank you for your insights on this story. You can follow this story and all things related to education at thecentersquare.com.